Going beyond the headlines. Asking the questions you want answered. Exploring government policies and how they impact you. We are delving deeper.
Good evening and welcome to Delving Deeper. I am your host, Ayana Carter. Joining us this evening is Senator the Honorable Reginald Armour SC, Attorney General and Minister of Legal Affairs. Good evening, AG, and welcome back to the show.
Good afternoon, Ayana. Happy to be here.
Well, firstly, how are you feeling?
I'm good. I've had an issue with my throat, my voice for a while, but it's getting better. But I'm good otherwise.
Now, AG, there's a lot being reported in the last week about the impasse between the Auditor General and the Minister of Finance. Your office has also been implicated in the matter as it relates to the Auditor General's legal advice and representation. Is there anything you can tell us at this time?
Well, there have been a couple press conferences in the last week. I actually had a press conference to put a couple things on record. And then I was asked to attend a post-cabinet briefing with the acting Prime Minister. So it's pretty much all there on record, the impasse between the Auditor General and Minister of Finance and tangentially, I guess, myself. What do I say? The position is clear. I received a request from the Auditor General for legal advice on a very specific subject. I replied and I said very clearly that on this issue I'm already advising the Minister of Finance, so it would not be appropriate. It would be a conflict of interest for me to advise you, but I recommend that you urgently seek independent legal counsel, and I undertake to pay your legal fees in that regard. Much has happened since then. Lots of letters have been written by her retained attorneys, and we are now involved in a lot of allegations about things very much outside of what I had undertaken to commit the public purse to. I stand by that, but it's now in the courts, so I think we'll just have to let the courts decide.
But is the state obligated to pay the legal counsel if, well, the Auditor General sought outside legal counsel? Is the state obligated to pay that?
I would not say it's obligated. There is always a responsibility on the part of the state, and certainly the Office of Attorney General, which I have the privilege to occupy, where a state official in discharge of that official's statutory or official responsibilities gets embroiled in litigation or needs advice in relation to the discharge of one's functions, there would always be a responsibility on the part of the state to indemnify that person so that that person doesn't have to incur personal expense. And in that context, I would say, yes, there is a responsibility. I wouldn't use the word always, because as this particular matter shows, we've gone beyond the pale. We've gone outside of the remit that I was asked to advise on.
AG, during the last week, the Cabinet took the decision to extend the Police Commissioner's contract for another year. If within the year, the Police Service Commission completes recruitment process and submits the nominations to Parliament, does the Police Commissioner's contract come to an end if the Parliament approves one of the nominees or candidates?
If during the currency of the present term, which the Commissioner of Police has now been extended for May 2024 to May 2025, if during the currency of that term, the Police Service Commission were to get its recommendations brought to the Parliament, and the Parliament approved one or other of those recommendees, what I would expect naturally would have to happen is that the commissioner, the incumbent commissioner, would have to consider whether she continues voluntarily or steps down voluntarily. At this point in time, she has an extension for a fixed period, and that fixed period is from the 14th for a year, and that term can't be affected unless she opts to stand down from that position or something happens in the course of her discharge of her responsibilities that would cause the Police Service Commission to take certain actions. So she'd have to voluntarily step down.
Okay. So it does not, that situation does not occur then?
A term doesn't come to an end.
The term doesn't come to an end when
if a
the
new
police...
nominee
right.
is approved by the Parliament.
Okay. All right. Now, as the government's lead representative for crime talks with the opposition and other stakeholders, where are we on these talks?
That's an interesting question, Ayana. My recollection is that in September of 2023, the Prime Minister wrote to the leader of the opposition, inviting the opposition to contribute a team to sit down with the government to engage in discussion on crime talks. That letter was written, by my recollection, that was written in September 2023. The Prime Minister followed up with that with a further letter in, I believe it was October 2023, appointing named persons to the committee, 4 parliamentarians and myself as the chairman, and invited the opposition leader to appoint 4 parliamentarians or 5, I forget the exact number. And the Prime Minister gave an agenda of specific items of legislation which would start the discussion. And the intention behind that, Ayana, was very clear from the government's point of view. The reality is that we go into Parliament, we debate legislation for the benefit of the public. It's all televised live. And sometimes, and I say this very carefully because I don't want anybody to accuse me of pinpointing persons, but sometimes people who are in front of a camera live tend to play to the gallery. They get carried away, and the thinking of the government was to remove everybody from that public spotlight, sit in a room, very cordial, and have an agenda and have a genuine, open, frank discussion about the state of crime in the society, the kind of legislation that can be looked at to bring about a resolution, happily, if possible, to get agreement on that legislation, because in some instances, the government would need what is called a supermajority to amend legislation that impacts the Constitution, or even to impact the Constitution, you'd need the support of the opposition. So the thinking was get people to sit around a table calmly, soberly, out of the spotlight of the public eye, and come to agreement, or calmly come to no agreement at all, but without the gallery. And then we would take it to the Parliament and we would pass it. The opposition never accepted that invitation. They immediately took to the media and fulminated, and I use that word quite deliberately, in a number of different ways. They tried to get the government to appoint persons who were not parliamentarians. The thinking was of the government to get members of Parliament who are the legislators to sit and have this discussion. And they are legislators because the public has elected them to represent them. So the opposition fulminated. They made a lot of noise. And to answer your question, where are we now on that? Nowhere. I eventually wrote to the opposition leader in November 2023, and I said, I refer to the correspondence, please let us have your nominees. She never gave the courtesy of even replying to me. I read something in the media by which she rejected what I had asked her to do. I didn't have the courtesy of a reply. It's gone nowhere. The opposition declined to sit and have conversations with government parliamentarians in a non-emotional way to address the problem that is facing this country, crime.
Crime is one of the main topics, on everybody's lips. How important then are these talks, to have these talks?
I think they'd be very important. I think that they, would have enabled, as I've said, at the risk of repeating myself, they would have enabled parliamentarians to engage each other meaningfully in an open conversation, discussion about the strengths, the weaknesses, the concerns, and air grievances and air concerns openly, things that may not be appropriate to be said on a public camera, and to engage each other so that we could listen to each other. We would have hoped that the opposition would have accepted that invitation. How important are those talks? Those talks are very important because it is what the public expects of its elected members. The public expects its elected members to seriously undertake the task of addressing problems that are affecting the country, problems that are affecting the communities, and to come up with solutions to address those problems, not simply to trade insults and to engage in emotional repartee, which is what takes place in the parliament right now.
The legislation to abolish preliminary inquiries is now in effect. Just about 5 months later, how is this process coming along, and has there been a dent in the backlog of court cases?
The process is coming along very well. I mean, the whole purpose of a JIPA, which is the acronym for the Administration of Justice Indictable Proceedings Act, the whole purpose of a JIPA was to abolish preliminary inquiries. Preliminary inquiries was the process by which someone would get charged with an indictable offense, and you get taken before the magistrate, and the magistrate has to be satisfied that what is known in law as a prima facie case has been made out, at which point the magistrate will send the case to the High Court, to the assizes. That's what preliminary inquiries were all about. What preliminary inquiries turned into was a trial before a trial, because at the magistrate's court stage, witnesses would be called, all the evidence in documentary form would be gone through, witnesses would be cross-examined. There are a number of preliminary inquiries which lasted upwards of 5 years, upwards of 10 years. There are 1 or 2 preliminary inquiries still in court today which are 13 years old and are not yet concluded. So that's what a JIPA abolished. A JIPA removed the preliminary inquiry trial before a trial and said everything had to be filed electronically, everything had to be in writing. The district court, which is what the judicial officer that has now replaced the magistrate in name and with some enhanced jurisdiction, the district court judge would, with the lawyers, look at the documents that have been filed and make a case whether a sufficient case has been made out in what is called a sufficiency hearing, and commit the person to trial for the crime that is charged. Where have we reached, and what's the result of that? Only this last week, we had a media release by the judiciary of a case of the state against Sheldon Boudram, a case in which the accused was charged and brought before the court in January of 2024. In April of 2024, last month, the judge, Justice Lisa Ramsume-Hines, found there was sufficient evidence to refer the case to trial. So that case has gone to trial, and she now expects that the case is going to be completed by July of this year. That's 6 months in place of 10 years. And very importantly, a JIPA and the criminal procedure rules which have been brought into effect 2023 and work alongside a JIPA give the judge, all judges, active case management control. The judges are in charge of the cases and they manage and monitor the caseloads. So for instance, in this particular case, Justice Ramsume-Hines appointed what is known as a case progression officer to stay with the lawyers, remind the lawyers of their deadlines, manage the deadlines. She's in fact made an order. The last order that she made in this case in April was to say that now that her order has been made for the progress of the case, no party, that is to say no accused represented by defense counsel and no state represented by the prosecution is allowed to change any of her dates by agreement amongst themselves. They have to come back to her. So the court is driving the process, and as a result of that, we are going to find that that case is going to be the first of many which executes a paradigm shift in the management of caseloads and the swift dispensation of justice.
Now, recently we observed 10 years since the violent murder of State Attorney Dana Seetahal. The men charged with her murder are still awaiting trial, and her family are still awaiting closure. How is AGIPA able to assist with addressing this, if at all?
Well, I want to be careful about what I say on this one. AGIPA will help considerably, but I want to be careful about what I'm going to say, because there has been an exchange of strong views in the media on the part of the Director of Public Prosecutions and the judiciary on that particular issue. And I certainly would not want to appear to be passing judgment on anything done by the independent office of the Director of Public Prosecutions. What I would say is that there are different positions that have been articulated. When you read what the judiciary has said, the judiciary has said AGIPA has made all the difference because all the evidence is now before you electronically. We sent it to you since December 2023. The DPP has replied and said the law on his interpretation still requires everything to be produced to him in paper, and therefore there are boxes of paper which have already gone digitally to the DPP through the judiciary's medium of electronic transactions under the Electronic Transactions Act and under AGIPA, and the DPP says, no, if I don't get it in paper, I can't start anything. I mean, the public will have to judge for themselves, but that's where the position is. I think AGIPA has made a significant difference, but it will now be a matter of interpretation whether the judiciary is right or the Director of Public Prosecutions is right.
Okay. Have all the issues been resolved with regard to the Director of Public Prosecutions, the Office of the Director of Public Prosecutions?
Well, all the issues been resolved. Let me put it this way. There are issues that impact the operationality of the Director of Public Prosecutions. One of those issues has to do with the physical location of his office, and you will recall the government, before I had joined the government, had rented office space on Park Street. That lease has now come to an end. It has been terminated by the government. But I can say that the Minister of Finance is in the process of purchasing another building, the former FCB, First Citizens Bank building on St. Vincent Street, with a view to housing the DPP and staff. The DPP, at the invitation of the Attorney General, has visited the premises, and that is now in the process of being examined by the different situation experts to make recommendations, but that building is going to be purchased by the Minister of Finance. So that deals with the infrastructural improvements. In terms of staffing, we have had considerable work being done with the Office of the DPP, the Permanent Secretary of the Office of Attorney General and Ministry of Legal Affairs, and the Judicial and Legal Service Commission have been hard at work. A number of offices have been filled in terms of State Council 1, State Council 2, State Council 3, and there is a significant move in terms of improving the staff competencies of the Office of Attorney General. In the area of ICT improvements, the DPP approached the Office of Attorney General and asked for certain improvements to be made. That is being addressed as we speak in his current building, and as and when the new building is obtained, all of the requirements that the DPP is asking for, within reason of the advice of the ICT Director, will be implemented to enhance his capability to deliver on his mandate.
Okay. Now, earlier this year, the Vincent Nelson case began in the High Court. It was held in camera. Is there anything that you could share on this case?
In limited terms, because the matter is in camera. And what does in camera mean? In camera means that a judge makes an order for particular reasons, either the judge of her or his own motion, or on an application of one of the parties to the case for reasons of sensitivity. In this case, what occurred was that Mr. Nelson had made an application for the case to be heard in camera, and The judge agreed. At a subsequent stage, I made an application for that to be lifted so that the case could be heard in public. The judge respectfully disagreed with me, and therefore the case has remained in camera, but the judge has said in her ruling that her decision will be made public. So that's where that is at.
All right. The Arbitration Act, AG, was proclaimed in mid-February. Now, in the simplest way possible, so everyone can have a good understanding. Can you explain what this means and what are the benefits?
Well, the first thing that I would herald from the rooftops is that the Arbitration Act passed in 2023, or I think early 2024, repealed the previous Arbitration Act, which had been passed in Trinidad and Tobago in 1939. So we have a piece of legislation, which I'm very proud of, that has brought Trinidad and Tobago into the sunlight out of a 1939 piece of legislation, which is what has ruled us since that year. Arbitration is an alternative process by which you get disputes resolved, and usually take place with commercial disputes, heavy commercial disputes, in which the parties come together, and the Arbitration Act is going to regulate that. The parties come together and agree on the choice of an arbitrator, and usually that choice is guided by the nature of the dispute. So if it is a dispute that has to do with solar-powered lighting, or if it is a dispute that has to do with some chemical treatment plant, specialized expertise, the parties will get together and choose an arbitrator who has experience in those areas, so that that arbitrator, she or he, can best understand the intricacies of the particular dispute. So the parties choose the judge, known as an arbitrator, and then the arbitrator, with the agreement of the parties, then proceed to make the rules which guide the process with a view to expedition. Bearing in mind, these are very expensive disputes, and the parties want to benefit from a swift decision. Everybody is prepared to move this forward as quickly as possible. Our Arbitration Act is modeled off of the United Nations, what is called the UNCITRAL model, which is accepted by hundreds of different countries around the world. So we've used the best model out of the United Nations, which has been adopted in a number of other different Caribbean countries, to model our law off of. And in a nutshell, it has to do with arbitration by chosen choice of the parties in areas of expertise that is peculiar to the area of the dispute, for an alternative process by which that dispute will be resolved. At the end of the day, the courts still have jurisdiction in limited terms under the Arbitration Act if the arbitrator makes fundamental errors of law, but other than that, the idea is get the arbitrator to resolve in as comfort, I was about to say consensually, but it's not strictly consensually, other than the parties have chosen the arbitrator to resolve this in the shortest possible time.
Now, AG, can you provide an update on the extradition case against former Minister Jack Warner in the context of the ruling made by the U.S. Supreme Court?
Yes, I can. The U.S. District Court has ruled, in essence, that the decisions which it makes in certain cases are not enforceable outside of the United States of America. And that has raised the potential for where decisions are made in a bribery case, which involves bribes coming from outside of the United States, that persons who may be charged outside of the United States, and the United States asks for those persons to be extradited to the United States to face the trial, it has raised the potential that that person can rely on that decision to say, well, the court has said that their decision is not enforceable against me. That was immediately appealed by the United States government. It is now on appeal, and in the meantime, the district courts have made it very clear that no other defendants are going to be allowed to take advantage of those decisions until the Court of Appeal has ruled. In the meantime, Mr. Warner's extradition remains in train.
Okay. Is there any update into the investigation into the missing Vindra Naipal Kulman case file and the malicious case brought against the state by the men formerly accused of her kidnapping and murder?
Yes, good news. I mean, after the men recovered an award of a 20 million judgment against the state, I retained Mr. Vincent Nelson, senior counsel, and asked for his advice. On the basis of his advice, we have appealed. That appeal from that decision was successful, and that $20 million judgment has been set aside. The other consequence coming out of that is I have started a process. I have engaged a consultant, and I have started a process of reviewing and doing studies on the entire operation of the Chief State Solicitor and Solicitor General's Department with a view to reform. That is in train, and therefore we are hoping to have learned from the lesson of that missing file to improve our processes for better service delivery and better efficiency.
Now, what can we expect from the Office of the Attorney General and Ministry of Legal Affairs in the coming year?
A lot, actually. There is a list of a lot of legislation that is in the pipeline to address issues to do with crime, criminal justice system, issues to do with, for instance, the returnee, what we call the returnee bill, where we have legislation that is going through a stakeholder consultation at the moment to bring back the persons, young people and widows of young men who joined ISIS and went off to Syria and that part of the world and are now in camps. We're drafting legislation to bring them home. That's going to involve a significant degree of infrastructural outfitting, because there will have to be, acceptance of national security considerations that have to be looked into very carefully. So we are consulting with the Ministry of National Security. We are consulting with the Ministry of Health. We are concerned because there will have to be psychosocial and psychological services provided, particularly for the young people. We are consulting with the Ministry of Education, because depending on where these persons live when they return, they will have to have access to education. So there's a lot of work being done in that area. We also have pieces of legislation to deal with things, something called controlled deliveries, which is to give the police the capacity to go out there and work in a particular manner to go after the criminal activity that is taking place in the country. Many other pieces of legislation. There is data protection, there is cybercrime, there is legislation to do with improving our statistical unit, and there is legislation to address other areas and other ministries. But a lot of work, and I'm quite looking forward to the work that we're going to be doing over the next couple of months.
All right, excellent. So you have been an open supporter of the Caribbean Court of Justice and this country signing on as one of the countries using the CCJ as their final court of appeal. Now, at a recent first public consultation of the National Advisory Committee on Constitutional Reform, there was a renewed call for this to happen. What's the savings clause? So I just wanted to explain what the savings clause is and how possible or how difficult it is to remove this clause from the Constitution.
Well, to answer the first question, what is the savings clause? The savings clause is a protection that is provided by our constitutions to ensure a degree of continuity and to save laws which were part of our legal landscape before our constitutions came into effect. So in this case, our Republican Constitution was passed in 1976, but there were many laws that were part of Trinidad and Tobago's legal landscape that pre-existed 1976. So the Savings Law Clause simply says that laws that existed before the Constitution came into effect, in this case, in the case of 1976, will be protected under the Constitution And if you are going to change those laws, then you will have to go to the Parliament and get a majority of the Parliament up to the level of 3/5, because what you are doing is you are altering constitutionally protected laws. So in the case of the CCJ has existed back to colonial times when it originated, when we were colonies, and not the CCJ, the Privy Council, when it originated when we were colonies, and at independence it became our final appellate court, and with 1976, our constitution, Republican Constitution, it has remained our final appellate court. So if we were to change from the Privy Council to the Caribbean Court of Justice, we will need the opposition to support the vote in Parliament up to the level of 3/5. And that for me is a matter of great concern, because I don't understand why the opposition, who brought the Caribbean Court of Justice into our legal framework. It was when Mr. Basdio Pandey was Prime Minister and Mr. Ramesh Lawrence Maraj was Attorney General, that the Parliament then of Trinidad and Tobago passed the laws to make the CCJ part of our legal jurisprudence and our legal structure, or judicial structure. So the CCJ is currently a Trinidad and Tobago court to interpret the Chaguaramas Treaty, but it is not at this stage our final appellate court replacing the Privy Council. Why the opposition continues, in spite of having introduced the CCJ, to oppose making it our final appellate court, I find that defies reason, it defies logic. And just to give one or two of the more powerful reasons why the CCJ is clearly the preferred appellate court. The CCJ at the moment works throughout the Caribbean. It works among countries that have accepted the Caribbean Court of Justice as their final appellate court. It works among countries that have not even accepted the Caribbean Court of Justice as their final appellate court. And it works in improving the judicial landscape for all Caribbean countries. So for instance, the Caribbean Court of Justice has two sub-bodies. One, which is known as the CCJ Academy for Law, that is chaired by Justice Winston Anderson, a judge of the Caribbean Court of Justice. The CCJ Academy for Law hosts seminars and workshops and training symposia to educate judges and stakeholders about the value of not just the CCJ, but important concepts in law. So in October last year, 2023, the CCJ had a significantly successful conference, one of many. It was held in Barbados on criminal justice reform. There were judges and legal practitioners from around the Caribbean participating in that conference, making very significant contributions. There were international jurists from the UK, from Canada, attending that conference. And it is all designed to help us to improve our administration of justice by having discussions which include academic discussions about the system of law that we adhere to and our judicial administration system. That's one arm of the CCJ that is working with all the countries of the Caribbean to improve our judicial and administration of justice system. Another arm of the CCJ is what is known as CAJU, the Caribbean Association of Judicial Officers. That association works with judges and judicial staff, not the wider stakeholder community, but judges and judicial staff from around the Caribbean, all the Caribbean islands. And it is chaired by Justice Peter Jamada, our own Trinidad and Tobago Justice Peter Jamada, who is one of the senior members of the Caribbean Court of Justice. And that body, CAJU, to use the acronym, is hard at work. January of this year, they did an intervention by invitation in the Bahamas, where they worked with judges on judicial education policy and a number of issues that the judges invited them to come and train Bahamian judges on. They're going to be doing it later in Guyana. They've been invited by Guyana. They are across the Caribbean in judicial education, court administrators, working with Caribbean judges, the high courts, the magistrates' courts, and other courts of the Caribbean islands. Do you find the Privy Council doing that? The resounding answer is no. We have this far removed body called the Judicial Committee of the Privy Council that is expensive to get to, so it makes access to justice almost impossible for 90% of our citizenry. They don't work among our judiciary and our Caribbean stakeholders to improve our administration of justice system in the way that the CCJ is currently doing. What possible reason could there be not to make the Caribbean Court of Justice our final appellate court? I hear this nonsense being put about judges being corrupt. I don't accept that our judges are corrupt, not our Caribbean judges, and certainly not our Caribbean Court of Justice judges. But even if one were to entertain that for a moment, I dare anyone to point to any single instance in the many years that the CCJ has existed, more than 10 years now, no instance in which any finger can be pointed at any member of the Caribbean Court of Justice who is in the least suspect at all. They are exceptionally good judges, women and men of the Caribbean who understand the Caribbean in which they sit and over which they preside and administer justice, not the far removed Englishmen and Englishwomen out in the United Kingdom who frankly condescend when they sit in judgment over us. So I call on the opposition to do a service to the people of Trinidad and Tobago. I made that call at the celebration for Mr. Justice Michael de Lavastide, which was held a joint sit-in of the Supreme Court and the Caribbean Court of Justice very recently to celebrate his life. It was attended by the Chancellor of the Judiciary of Guyana. It was attended by judges from Barbados. It was held right here in the Caribbean, in Trinidad and Tobago, in the Hall of Justice. And I said then, when I paid tribute to departed Justice Michael de Lavastide, the first judge, first president of our Caribbean Court of Justice, I said then that we should celebrate his life by having Trinidad and Tobago finally accomplish his dream to make the Caribbean Court of Justice our final appellate court in place of the Judicial Committee of the Privy Council.
So is that non-support the only reason why the CCJ is not this country's final court?
Oh yes, because this government is committed, but it can't take and that would have been a discussion we could have had, not to do with crime, but that's a discussion we could have had at a table, sitting down in the quiet of a rational room of conversation to say to the UNC, why are you opposing the CCJ? You started that ball rolling. Help us to understand so we can meet you halfway. We weren't able to have that conversation because they refused to meet with us. But the reason why we have not yet taken a bill to the Parliament is because we need the opposition support, and they are shouting from the rooftops that they will not support the CCJ. The short point is we are a bright, creative, intelligent people, not just we lawyers, but all of us in the Caribbean, in Trinidad and Tobago. And there is no possible reason why we should so lack confidence in ourselves to be the final court of appeal for our people. So I genuinely find that question almost impossible to answer. I think that there are self-interested, self-serving reasons why people are promoting an untruth to suggest that the CCJ is not up to the mark. They are far and above and beyond the mark in terms of competence. So I think it's self-interest, narrow political self-interest, and narrow self-interest that is promoted by a lack of self-confidence.
Now, any final thoughts, AG?
Well, I mean, I'm happy to be here once again on Delving Deeper. I always appreciate the opportunity to engage with the listening public in rational, mature discussion without being distracted by sound bites. And I look forward to further opportunities to continue this conversation in the near future.
And you know you're always welcome here.
Thank you. Yes.
And that's our show. Thank you, AG Armour, for joining us on another episode of Delving Deeper.
Thank you very much, Ayana.
Join us at the same time next week for another episode of Delving Deeper. I am your host, Ayana Carter, and from all of us here, have a good night.